Understanding the law is the first step to fighting back. Here's what the federal government just built inside America's airports, and what it means for your family. Since March 2025, the Transportation Security Administration, TSA, the agency that runs airport security, has been sending ICE passenger lists multiple times every week. Those lists include names, dates of birth, photographs, and flight details. ICE runs those lists against its own deportation database. When there's a match, agents show up at the gate. The first time most Americans heard about this program was in December 2025, when the New York Times published an investigation. But the program had already been running for 8 months, and it had already changed lives. On November 20th, 2025, Annie Lucia Lopez Beyoza arrived at Boston's Logan Airport. She was 19 years old, a college student. She was flying home to Texas to spend Thanksgiving with her family. She was told there was a problem with her boarding pass. On her way to the customer service desk, she was surrounded, handcuffed, and removed from the airport. Within 48 hours, she had been deported to Honduras, a country she had not lived in since she was 7 years old. A federal judge had issued an order specifically barring her removal from Massachusetts. The government deported her anyway. A court later found that deportation was illegal. Her story is not an isolated incident. It is a window into a new enforcement reality. Here's how the program works. TSA and ICE are both divisions of the Department of Homeland Security. Because they are in the same department, the privacy rules that normally prevent one government agency from sharing your personal data with another do not apply between them. The administration has used that structural fact to build a surveillance pipeline inside the commercial air travel system. When you book a flight, TSA receives your passenger information as part of standard security screening. That data was collected to keep dangerous people off planes. Under this program, it is now also used to identify immigration enforcement targets before they board. TSA's acting administrator testified before Congress in January 2026 and confirmed the program exists. She said it was, in her words, absolutely within their authorities. She did not describe what limits, if any, exist on how ICE can use that data, which categories of people are being targeted, or how the program handles mistakes. That last part matters, because the program has already swept up people it was not supposed to reach. ProPublica documented more than 170 United States citizens arrested or detained by ICE in 2025. More than 20 were held for over 24 hours. When DHS Secretary Kristi Noem told the public that no American citizens had been arrested or detained, NPR fact-checked that claim and rated it false. One U.S. citizen described being detained at a work site. He said he repeatedly told agents he was a citizen. He showed them his ID. He said, "Let me prove to you my legal status." They don't care about that. He described agents dismissing valid government-issued identification as fake. When federal agents are detaining American citizens and refusing to accept their IDs as proof of citizenship, the question of who is actually safe at an airport becomes a serious one, for everyone. Now let's talk about who faces the highest risk under this program. If you have an old deportation or removal order, even one from years ago, even one you did not know existed, you are at significant risk at any U.S. airport. Many people have removal orders in immigration court records they were never notified about, or orders that were entered when they were children and did not appear in court. Those orders do not expire. They remain in the database, and ICE can act on them. If you have a pending immigration application, asylum, a green card renewal, adjustment of status, that pending status does not protect you. ICE has arrested and detained people in active application processes. A file that says pending does not mean protected. If you have any criminal history, including arrests where charges were dropped or cases that were closed, those records can still trigger immigration enforcement. Immigration law defines convictions differently than criminal law. A case your attorney told you was finished may still carry immigration consequences. Green card holders are also at risk. Lawful permanent residents with certain criminal convictions, including minor offenses, have been detained at airports. Having a green card does not make you immune. people whose temporary status has been revoked or is under threat, including temporary protected status holders from countries like El Salvador, Haiti, Venezuela, Nicaragua, Cuba, and Honduras, face elevated risk. The government has been terminating programs that previously provided protection, sometimes with little notice, and DACA recipients are on this list too. The program has seen ICE detain individuals with active deferred action status. The common thread across all of these categories is this: legal status that was once considered stable is now uncertain in ways it was not before. If you are planning to travel, you need to know your individual situation before you get to that security line. Now let's talk about the scale of what has been built around airports, because the TSA data sharing program is only one piece of a much larger enforcement infrastructure. Since January 20th, 2025, the federal government has conducted at least 8,877 immigration enforcement flights. That number comes from Human Rights First's ICE Flight Monitor, which tracks publicly available aviation data. It represents a 62% increase over the same period in 2024. In September 2025 alone, there were 1,464 enforcement flights, the highest monthly total ever recorded. That is an average of 49 flights per day. These flights are not all deportation flights to other countries. The majority, more than 5,300 between January and September 2025, are domestic transfer flights. People in ICE custody are being moved between detention facilities across the country. They are being shuffled from one detention center to another, sometimes crossing multiple states in a matter of days, as the system searches for available beds. Human Rights First documents what those flights look like. On enforcement flights, detainees are nearly always restrained with handcuffs, waist chains, and leg irons, including during layovers and fuel stops. The conditions raise serious human rights concerns, and advocates argue the rapid pace of transfers makes it nearly impossible for detainees to maintain contact with legal counsel or family. Detention levels peaked above 61,000 people in August 2025, a historic high, and 48% of those detained nationwide had no criminal conviction and no pending criminal charges at the time of their detention. In New York State, that number reached 60%. To put that in plain terms, more than half the people filling these detention centers and boarding these enforcement flights had no criminal record. They were detained because of their immigration status alone. This expansion is not happening without resistance. In January 2026, the government watchdog group American Oversight filed a federal lawsuit against TSA and ICE. The lawsuit followed Freedom of Information Act requests that the agencies refused to answer. American Oversight is demanding the contracts, memoranda, and agreements that govern the data sharing program, the legal authority behind it, what data is actually being shared, what safeguards exist, and whether U.S. citizens have been caught in enforcement actions. The lawsuit notes a pattern. This is not the first time the administration has repurposed data collected for a different purpose into an immigration enforcement tool. A separate court order already forced the administration to release an agreement between the IRS and ICE to share taxpayer information. Privacy advocates and civil liberties organizations argue that turning airport security screening, a system people have no choice but to use to travel, into an immigration surveillance tool raises serious constitutional questions about due process, equal protection, and the government's use of data it collected under entirely different circumstances. Members of Congress have also raised concerns, particularly about the lack of public notice when the program launched and the absence of disclosed safeguards. The program remains active. The litigation is ongoing. The outcome of that lawsuit and any similar legal challenges will matter. Because if courts find limits on what agencies can do with this data, or demand transparency about how it is being used, that shapes what enforcement looks like at airports across the country going forward. For now, the program operates. Flights keep moving, and families trying to understand their risk need accurate information. So if you or someone in your family is planning to travel by air, Here is what you need to know right now. Before you travel, speak with an immigration attorney about your specific situation. Old removal orders, criminal history, expired or pending status, revoked programs. These are facts an attorney can evaluate. Do not assume that because you have traveled safely before, the same rules apply today. The program launched in March 2025. Travel before that date gives you no information about risk today. Bring physical copies of your documents. That means proof of lawful status, any pending application receipts, and, if relevant, certified court orders showing your case was closed. Print your boarding pass. You should not need to unlock your phone to board. Secure your devices before you travel. Sign out of email accounts. Disable biometric unlocking if possible. You have the right to refuse consent to a search of your phone or electronic device without a warrant at domestic checkpoints. But be aware that at international ports of entry, border officers have broader authority, and refusing can result in denial of entry. Do not sign anything under pressure. Documents signed at checkpoints can include voluntary departure agreements that create a formal order of removal. If an agent hands you something to sign and you do not fully understand what it says, you have the right to refuse. Ask for time to consult an attorney. Know the EOIR hotline, 1-800-898-7180. If you or someone you know has an alien registration number, you can check immigration court history through the Executive Office for Immigration Review. Old removal orders sometimes exist in the system without the person ever knowing. And if you are arrested, do not answer questions about your immigration history without an attorney present. You have the right to remain silent. State your name if asked, but you are not required to say more. Ask for a lawyer. Do not waive any rights in writing without legal counsel. Stay informed and know your rights. Record today, protect tomorrow.